At this time, we'd like to provide short answers to commonly asked questions by injured people. It seems that most every day somebody comes in and asks me, Tom, do I really have a case, and is it worth pursuing? Sometimes prospective clients even apologize to me that they're talking to me because they don't think the claim may be worth pursuing. Let me say this, if you have been injured by the fault of another, you should see an attorney who cares enough to represent you to get a recovery for medical bills, for your lost wages, something for your injury, regardless of the value of the case. It shouldn't matter if it's a small claim or whether it's a very large case. Attorneys should provide you the help you need. That's what we're there for. Another commonly asked question at a first meeting with clients is, how much is my case worth? That's a fair question, and that you have a right to know. However, I always tell clients at a first meeting that it would be improper for me to tell them what they can expect at a first meeting. The reason is simple. I don't have adequate documentation and information in order to place a proper value on your case. That should be done after you're released from the doctor. You have all gathered the medical bills, the lost wages, information regarding the nature and extent of your injury, whether it's a temporary injury and you made a full recovery, or whether you're left with chronic pain or even an impairment rating, future medical bills, ongoing pain and suffering and such. Once all of that documentation is provided, I'll be able to sit down with you and give you a proper range of value of what your case should be. The range will include a value that a jury would return in a verdict, an expected verdict. We also subscribe to jury verdict research. This is a service that has over the last 10 years databased information on cases all over the country that have over 20,000 verdicts and settlements in their database. We are able, for any geographic area and any type of injury, put in case-specific information to get an expected range of value. That's helpful to clients to understand what values are for different kinds of cases. It's not something that we necessarily need in our practice in order to evaluate cases, but we have found it does help clients. We don't always agree with jury verdict research, but if we don't, we'll tell you why. We'll explain why your case is different and won't fit necessarily that jury verdict expected settlement or verdict range.
Among the many questions asked by clients, one is, will I have to go to court? Many folks are fearful of going into the courtroom, the anxiety that goes along with it, the uncertainty. And obviously it's a very good question. Statistically speaking, most cases, most claims do not end up in court. Approximately 90% of the cases eventually end up settling. Some cases, lawsuits have to be filed, go through part of the litigation, pre-trial litigation process, and the case settles. But for the most part, cases settle before a lawsuit is filed. So, will you have to go to court? The answer is probably not. Do you go to court or must you go to court? We would only advise you if it's best for you to go to court to advance your interest. That is, if the other side, the insurance company or the corporation on the other side is mistreating you by giving you an inadequate and unfair offer, we would analyze that offer and what we think an expected jury verdict would be, as well as what the cost would be, so that you can make a decision whether it's appropriate for you to go to court or not. We, of course, would advise you as to what you should do, but ultimately it was a decision that you would make as to whether it's appropriateness of going to court or not. Another frequently asked question is, how long will my case take to resolve? I've heard all these horror stories where it takes years, 10 years before my case goes to court and I finally get some money out of the claim. In most instances, your case will take as long as it takes for you to go through the healing process, as long as it takes for us to make sure we have all the adequate and necessary documentation, records, to be able to support your claim, and then we go to negotiate. Many claims can be resolved within perhaps as little as 3 months, 2 months perhaps, and some instances go on to nine months, a year, or beyond. But only in those instances that you need to go to court, the case normally will take a little longer. And here again will depend upon your stage of recovery, whether you've made a complete recovery, and if in fact your case can settle at a pretrial mediation, it might be able to forego the courtroom because of an offer being made. But it still goes back to getting resolved based upon what's fair and appropriate for you after we've analyzed it and given you our opinion.
Clients always ask, how are attorney fees paid? Typically, attorney fees are based on a contingent fee, that is a fee based upon getting a recovery for the client, certainly a recovery that the client approves. In all instances, contingent fees can be either a flat percentage fee of the gross recovery or an increasing fee. Fees may increase from 1/3 if it's settled to as high as 40% if a lawsuit's filed, or even as high as 45% if you go to trial. At Blackburn and Green, we have always charged a flat 33 1/3% of the gross recovery, whether the case settles out of court or whether we take the case all the way to a jury trial.
In many instances at the first meeting or even perhaps even in a telephone interview, clients are foremost concerned about cost. That is, what it will cost them to be able to pursue their claim. And cost being different than fees, fees are what an attorney would take based upon a gross recovery, a percentage of gross recovery, as we do in Blackburn and Green. But costs are different. That is, cost of medical records, cost of an appropriate investigation, cost of accident reconstruction. Those are examples of cost that may or may not apply to your case as far as incurring those costs. We advance, all consistent with the canon of ethics, we advance those costs and take those costs out of any settlement or judgment at the end of the process. It is possible, if there is no recovery, that the cost ultimately would be your responsibility. But rest assured, we would never ask you to be exposed to that prospect unless we at Blackburn and Green felt strongly that we'd be able to recover the cost and be able to make sure that you receive fair compensation. So the expenses are fronted by us until such time as a recovery or a jury verdict, in most, if not all, instances. In Indiana, a personal injury claim must either be settled or a lawsuit filed within 2 years of the date of the harm. By personal injury claim, I mean to include things such as an automobile collision, medical malpractice, slip and fall, dog bite, products liability, and wrongful death. There are some exceptions to this 2-year rule. For example, involving an injured minor or infant still may be able to bring the claim beyond the 2-year period. A claim involving someone that's under a legal disability may be able to bring their claim beyond the 2-year period. And in those instances where the harm cannot be discovered in a reasonable fashion within the 2-year period, you may be able to bring the claim beyond the 2-year period. The vast majority of cases in Indiana fall within the 2-year period of statute of limitations. However, because of the exceptions that we've just noted, it's best that you call an experienced attorney as soon as possible to determine whether your case falls within or without those exceptions.